Welcome back, everyone. Today we actually have got a surprising and extremely serious update to the whole Activision Blizzard situation. It's really not the sort of thing that most people expected to see happen, and that's why it is an important story for us to cover, because it could change a lot. Now, your context here is that a few weeks ago, ActiBlizz reached an agreement with the US Equal Employment Opportunity Commission, right? Now, that's the one that had the 18 mil fund to compensate people, that also had a basic list of things that Activision Blizzard would have to do. Now, ActiBlizz seemed very happy about this settlement because they, well, marketed the shit out of it, basically. Now, Code CWA, which is the workers' union, they filed a complaint against ActiBlizz with the National Labour Relations Board, calling the settlement a slap in the face. Because, let's be real, it's 18 mil. Think about Bobby's 150 million odd total compensation. Yeah, not that much money. So that's the context, and with that in mind, you've time to get into what's changed. So the California Department of Fair Housing and Employment, who are the people who launched that initial lawsuit that we all heard about a few weeks or months ago, they basically challenged the settlement. So basically the state agency has challenged the federal agency. Now they are saying that the settlement leads to the effective destruction of critical evidence in the DFEH's own case, and that will cause irreparable harm to the suit. Because basically, if people agree to the settlement terms, then I believe like they're just considered, there you go, above board, problem solved, which would be damaging to their case. Plus a few other things. They highlight some of their points here. The proposed consent decree contains provisions sanctioning the effective destruction and or tampering of evidence critical to the DFEH's case, such as personnel files and other documents referencing sexual harassment, retaliation, and discrimination. And they're basically arguing that the terms are really good for Activision Blizzard and will protect Activision Blizzard from their own case, and they're also not at all happy with 18 million. Now, we remember that's the same department that threw out, or challenged anyway, the $10 million settlement with Riot, saying that it could be up to 400 million that's really owed. So this sort of State Department, they're pretty aggro when it comes to cases like this, seemingly a lot more so than the federal department that we've just talked about for the context. Now, here is where it gets very surprising, because some basic legal shit seems to have not really been followed. Some basic principles have not been followed, and this could severely damage the case in a way that could be quite bad for workers. So the EEOC responded to the DFEH basically being angry about their settlement. Now, this document is heavily redacted in the public release, but it's massive because it's essentially a big conflict of interest allegation. So here's the deal. Two of the attorneys currently working for the DFEH themselves previously assisted the EEOC with the EEOC's investigation of Activision Blizzard. Now, the EEOC are alleging that those attorneys worked to develop the settlement that they are now objecting to. So these attorneys helped the EEOC do the thing that led to the $18 million settlement. Those attorneys then end up working with the Californian, the DFEH, and now those same attorneys are arguing against the settlement that they sort of helped out earlier. I guess law people just, do their job, right? They perform their function, and I suppose the ideal is that the overall system, assuming the rules are being followed, the system works the problems out, which I suppose is why, like, a defense lawyer is expected to defend where anyone else would think that the person is indefensible. That's like kind of the way it's set up. So it's interesting when you think about this in an overall legal context. Now, if these allegations are true, then it would likely constitute a conflict of interest, which itself would constitute a breach of professional ethics and a violation of the Californian Rule of Professional Conduct, which governs the conduct of attorneys. The exact wording is here specifically to DFEH attorneys who played leadership roles in the organization, previously served as EEOC, who helped to direct the EEOC's investigation into the charge against Activision Blizzard. The same attorneys then proceeded to represent the DFEH in connection with these intervention proceedings, which seek to oppose the consent decree that arose out of the very investigation that they helped to direct while at the EEOC. And you've got to admit, it does feel a bit weird that, the tune changes. Now, the EEOC are alleging that this is a substantial breach of the rules that apply to all of the attorneys working on the case. And they allege that the DFEH realized this issue after the fact and basically tried to cover it up. The EEOC is claiming that they hired new lawyers following this belated realization, but almost immediately served a new appeal that clearly had involvement from the previous two lawyers. Now, apparently these two lawyers in question had already been approached by the EEOC regarding this, but they just ducked out of the call. Beep. Problem solved. Nothing to see here. Now, I know you're here for game industry news. This is game industry news. It's just it's all tied up in legal stuff that honestly can risk being so dry and so boring. But this does impact what's going on to a very important case in our industry. So the EEOC are super nettled about this. They say that the two attorneys in question were obviously significantly involved in the case across both sides, and because they were directing other members of the DFEH team, all DFEH attorneys were and should remain barred from representing the DFEH in this matter. Now, this could block the DFEH complaint against the EEOC from moving forward. And then this gives loads of ammunition to Activision Blizzard whenever Activision Blizzard is trying to say, no, we sorted the thing with a federal agency. California Department, look at all these conflict of interest violations and professional code of conduct violations you lot have. Right, you can see the optics, you can see the spin. You can also see the spin as applied to, the stock market. Which, of course, that's who Bobby's communicating to. Not you or me. Now, they also say that because of the conflict of interest allegations, everything the DFEH have worked on up until now is, quote, a product of prohibited representation that should bar DFEH attorneys from providing work, product, or advice to current counsel related to these proceedings. So in short, shit show that will totally hamper these proceedings. Now, to try to make some sense of this, the industry have talked. So PC Gamer have talked to people. Richard Hoag, of course, has done some talking. So let's go into that. Right. Andrew Torres is a Harvard-educated lawyer, co-host of the Opening Arguments podcast. He did a big Twitter thread. Here's a little bit of a summary. The EEOC understandably freaked out about the two lawyers. DFEH quickly engaged outside counsel and put a few new folks in charge of the intervention, but if the facts are as they appear, the entire DFEH investigation may violate, basically, the rules. The entire investigation. That's the investigation that we've all been talking about. Now, this is not saying that what the investigation found is wrong or anything like that. What this is saying is in the conducting of that investigation, two of the attorneys involved who seemingly played a major role had, were basically breaking professional conduct rules, conflict of interest, right? If DFEH just failed to screen the former EEOC lawyers, then the DFEH is in trouble. But if it let those lawyers run the investigation of Activision without permission from the EEOC, then things are going to get very ugly. Can't wait to see the DFEH's side. As for Richard Hoag, of course, many of you will know he's quite active in the game scene. Holy crap, I said that CA was apparently upset about the EEOC, but it may be much worse than that. Whole thread is worth reading, but EEOC is alleging DFEH investigation is headed by former EEOC attorneys who worked on their Activision case. If this is in fact the case, professional ethics rules would apply. This is a pretty massive thing, and if true, would call into question large portions of the DFEH process, certainly as against the EEOC directly. It might even provide Activision with its own defense of the original suit. Stay tuned. Holy shit, what do we make of this?
I think it's extremely disappointing because I think this is the problem where everyone sees the problem. Everyone knows what the lawsuit was about, and this means nothing for what they found, what they investigated, or any of the problems that ABK employees are facing. But it's all just going to, not going to, but there is a possibility that it all just falls by the wayside entirely because they just didn't do their due diligence in this case. to make sure that, because obviously in law, you can't just say, yeah, we've got evidence. Sure, there are so much protections for how you get evidence and how you actually handle legal things, how you get them into court, how you actually, the whole process needs to be squeaky clean.
Yeah.
And they've just went, whoops, sorry, we didn't ask if there's any conflict of interest, so now the entire lawsuit is a possibility of being thrown out because that's how it has to happen in law for law to be effective, which in this case means that, now every possible remuneration or any sort of damage that could be done to Activision Blizzard as a result of their misdeeds is now completely under question.
Yeah, it's a total shit show. It completely undermines the DFEH's, I don't mean like the credibility of the substance of their argument for this investigation, but it does undermine some credibility in like them professionally as an organization, how they're dealing with things. And usually in a thing like this, if you can't win in the facts, what you have to do then is character assassinate, attack credibility and stuff. And frankly, they should lose credibility if they have done this stuff wrong. Now, this is not to say that the things, again, the things that are in that case are the big issue. You have to remember the EEOC's own case did find loads and loads and loads of problems. It's just that it's 2016 onwards, not historical. So it's not really about what literally happened in the halls of Activision Blizzard. It's far more about the legal process stuff. And it's a shame that rather than these, I suppose, arms of the various governments doing the job the taxpayers pay them to do, that instead we're embroiled in all of this bullshit because people didn't do their friggin' job right. That is a big pity because it drags the whole thing out. It adds in a bunch of mess and it adds in a bunch of noise that is not signal, that just wastes people's time and energy, and ultimately provides a resolution, or ensures that a resolution, whatever direction it goes, is going to be belated. So it sucks.
Yeah, especially when you think about, what's Activision Blizzard doing right now? They're probably laughing. They're probably going, oh, fantastic. The two people, the idea of the enemy of your enemy is your friend just doesn't apply here, because the EEOC went, we've got our opinion, we've got our findings, and now they're just, the two legal entities attacking Activision Blizzard are now in a fist fight, and Activision Blizzard are standing on the sidelines going, oh, I hope the EEOC win. Or it doesn't matter, and no matter how it goes, we'll win in the end of this, so fantastic.
Trial by combat.
Yeah, except it's Activision Blizzard aren't involved in the trial by combat. They've now snuck out of the actual court, metaphorically speaking. They've snuck out of the court. They're just free, going, haha, class. We don't have to do shit. Yeah, fantastic.
Now the EEOC is their nominated champion, and with that, there is actually an update to this where the Communication Workers of America, which is like the union, they have actually issued their own challenge to the agreement. So they'd spoken out about it before. This is, of course, a good bit more substantial. Basically talking about a number of serious deficiencies. They've also requested a fairness hearing from the court in order to examine and address the shortcomings in the settlement. And there's a letter submitted with 31 points of concern. Things like requests for additional documentation and explanation on some of the more nebulous parts of the settlement. Generally, if there's something legal and the verbiage is nebulous, that means there's wiggle room, and that wiggle room, is a useful thing. As an example, eligible claimant, because only people who fulfill a set of as yet unspecified criteria will be able to avail of the paltry $18 million fund. A fund that they say is woefully inadequate, suggesting that it could only provide the maximum settlement for up to 60 people, which is implying that it's basically probably going to be a pittance to a large number of people, and certainly not enough money to make the company bat an eyelid. They have 9,500 staff. So they're worried about the fair distribution of the settlement fund. They also, say that other parts are woefully inadequate. As an example, the provision of 1 hour of a private attorney for each claimant, or the stipulation that HR employees will have to undergo 2 entire hours of training. I mean, how could all the problems not be solved in just 2 hours? One of the larger sticking points, though, is the requirement for people to, sign a waiver, right? So they're keen to ensure that this stipulation does not waive any other claims under federal or state law or any other applicable law. So it's basically, if you, sign away your release for the federal settlement, do you then sign away your right to be a part of the state settlement? If, the DFEH is able to get its stuff off the ground. That's obviously not good, that, if the federal, body is going to be a lot more easy on ActiBlizz, and ActiBlizz want everyone to sign up with them and, release themselves from the DFEH one. Now, this is a similar concern to what the DFEH have already expressed. Of course, then the question is, will the EEOC try to basically body the CWA as well? The bodying of the DFEH we've covered in this video, of course, and the presiding judge even slapped down an attempt by the DFEH to file an opposition to the EEOC's allegations sooner than the standard timeframes permit. So, as with all things legal, it's not going to be expedient, it's going to be bloody boring, but it's also the sort of thing that is also quite important. That's really it for the update. I mean, it's more going on and it's hardly surprising, so let's hope the pressure keeps up, the people don't forget about this story. That's why we still choose to cover it pretty much whenever we can. I think it's important to keep this story alive and, in people's minds, because it is important, even when it's not the most spicy like it was when it broke and it was just kind of clicks for everyone. So, yeah, there's that. That's the update. We'll have to just wait and see what happens, but that's it from the two of us. Thanks for watching, and we'll see you next time.